everybody. It's 8 o'clock and welcome to the 30th episode of Marvelous Medicine. On March 9, 2018, the Supreme Court five-judge Constitution bench headed by Chief Justice at that time, Deepak Mishra, expounded that passive euthanasia and advanced living will are permissible and human beings have the right to die with dignity. The apex court bench also said that living will be permitted, but with the permission from family members of the person who sought passive euthanasia and also a team of expert doctors who say that the person's revival is practically impossible. The bench further added that it had laid down guidelines on who would execute the will and how passive euthanasia would be granted permission by the medical board. Its guidelines and directives shall remain in force till a legislation is brought to deal with the issue. Unfortunately, till date, we still don't have a legislation, and that is why this topic came up when Dr. Krishnamurthy saw this news item in the Times of India in February 2021, which said that why is registering a living will such an arduous task despite the Supreme Court guidelines. So the story was of a retired professor of anatomy who was unable to register her living will, which she had drafted in 2019. And on examination, what was found was that there were absence of standard operating protocols at the center and state level, and executing the directives before the judicial magistrate first class and the three-tiered process for approvals for actual decision making are extremely arduous. The Indian Society of Critical Care Medicine has represented the difficulties in implementing the court's guidelines, and the ICMR has developed guidelines for do not attempt resuscitation orders, and several hospitals like All India Institute and other organizations have framed their own internal policies. So what we now have is a very complicated situation, and though death is sometimes end of suffering and not life, we are not able to die with dignity. So for all those who are joining, living will is a written document that allows a patient to give explicit instructions in advance about the medical treatment to be administered when he or she is terminally ill or no longer able to express informed consent. Passive euthanasia is where there is a withdrawal of medical treatment with the deliberate intention to hasten the death of a terminally ill patient. As doctors, most of us feel that the use of the word euthanasia for withholding treatment in a futile situation is what has made it even more difficult for us to implement this. So, to help us go through this conflicting situation, we have Justice Kannan Krishnamurthy. He's the founder director of Madhyastham, a conflict resolution portal involved in mediation and arbitration practice since July 2019. He holds a bachelor's degree from Loyola College, Chennai, and he studied law at the Ambedkar Law College, Pondicherry. He's a former judge of the Punjab and Haryana High Court and has served as chairman of the Railway Claims Tribunal, New Delhi. He's the author of several books on law, including medicine and law, and he's also the revising editor of the long-standing book, a textbook of medical jurisprudence and toxicology. To moderate the session, we have Dr. S. Javeri. He's the head of critical care and emergency medicine at Regency Health Super Specialty Hospital, Lucknow. He has a Chennai connection. He did his MBBS from Stanley Medical College and his diploma in anesthesia from Aligarh Muslim University. He has done his Indian Diploma of Critical Care, European Diploma of Intensive Care, and he's a fellow of the Indian Critical Care Society. He's involved in several educational activities at the national and international level and has several publications to his credit. He is committed to build a strong critical care outreach program, knowing that we have a severe lack of intensivists in our country. Co-moderating will be Dr. Vasanthi Vidyasagaran. She's an emeritus professor of Dr. MGR Medical University, Tamil Nadu. She did her MBBS, DA and DNB from Madras Medical College. She retired as the director of the Institute of Anesthesia and Critical Care, Rajiv Gandhi Government General Hospital. She's the founder of PrEP, a unique teaching program for anesthesia postgraduates which started in Kilpauk Medical College and still continues. He has trained more than 75,000 undergraduates for postgraduate entrance exam at Speed Medical Centers across India. The founder of Anesthesia Academy, which runs a teaching program for postgraduates, which is continuing despite COVID online. He's the author of 2 books, Learning from Experience, Amazing Anesthesia Anecdotes. I would suggest all of you to read it. It's nothing short of a bestseller. And the other one is A Wake Up Call, Stories from the Operation Theatre, meant for public education. He's involved in several public awareness campaigns, including print, radio, and TV programs. With that, over to you, Justice Kannan.
Thank you, Dr. Vidya. You have given quite a long introduction to the topic of what you said about living will, advanced directives, the issues of euthanasia, how it has come through a judicial pronouncement, and the difficulties of what you encounter. You literally touched upon every vital issue of importance. If there is a judgment, there ought to be clarity. If there is a pronouncement of the highest court, which is the law of the land, is to ensure that there are clear guidelines for the medical professional, for clear way of understanding one's own life, what that person wants his body, physical frame to be treated, how it is to be treated. There ought to be a reason for celebration. We have something now. There is greater certainty. Things are better. But then, unfortunately, there lies the whole problem. It has been much talked about because it comes with so much of difficulties in enforcement. You were talking about some colleague of yours, probably a relative who wanted to have a document made, but it was so very difficult. It was not getting to happen. And what difficulties that they underwent, and probably didn't ultimately get to be done at all. So what are we looking at? What do we understand the living will to be? What are the issues relating to how is it prepared? How do you register it? Who acts on that? What happens if the family members are not prepared to accept? What would happen if the doctor is not prepared to accept what is given there? If there is a conflict between the doctor's view and the medical board's view, whose view prevails? And if all of them fail, and who goes to a high court?
Hello,
which court
can't hear you
does
properly.
one go to? So these are all
Can't
the
hear
issues
you.
which will keep coming. Yeah. Do I?
If possible, please come a
Can't
little
hear
closer
you
to the
properly.
mic.
Yeah.
Dr. Mohan Rao, are you using headphones, sir?
Yeah,
You want me to use a headphone?
I'm using headphone.
No,
Can't hear you
no,
properly.
sir.
No, sir. Kannan sir, you are perfectly audible. I think there is an issue is with Dr. Mohan Rao, sir.
Yeah,
Exactly. Yes.
audio is perfect, sir.
Yeah.
There's no issue. Please carry on.
Okay, so it's just a manner of introducing the topic for you, and I'm now that there is a panel which is there, I'm sure you'll navigate the conversation and to make it happen. So my idea is to let you know that the pronouncement of what has come through the Supreme Court comes with a lot of difficulties. The attempt of the Supreme Court was that this advanced directive is not misutilized. Someone doesn't trash it, or someone doesn't force a person to give a directive that he wants his life to be not dealt with by any medical care. So how do you bring all those cautions? How do you ensure that the person has the best of information at the time when he makes the instrument? And how do you bring credibility to its enforcement? Who should be the judicial officer who will actually see whether the patient requires any attention at the time, or is he well off being withdrawn? Is he really in a critical state where there is no chance of survival? Those are the things which we will confront. And again, this issue does not answer all kind of things. The advanced directive of what this judgment refers to is not an expression which was coming for the first time. It was used also in some other circumstance in Mental Health Care Act in 2017. They made a reference about advanced directive, but it didn't come with so many trappings of technical details of how you go about it. It was a simple statement of how a person who is in a mentally fit wants himself to be treated if he ever goes into a mentally unstable situation. That is, when a person in a lucid interval, what type of directive he can give. How would you want any directive to be given to any person? How does he authorize some person, a medical attorney, who will take decisions on his behalf when in this state of ill health? So therefore, there was already a legislative expression coming through the Mental Health Act. But then when this pronouncement was made 1 year later in 2018, they put in so many difficult issues of enforcement and registration and all that. And again, when you're talking about euthanasia, it all started with the issue of somebody taking his life away. This is not something which is unknown to us, because there is even a religious tradition amongst Jains that it is seen as one of the best methods of shedding body, that you negate your own physical self and then you go into a state where you can take your life away. So this was even challenged before the Supreme Court. This kind of a practice is wrong. There is a provision there under the Indian Penal Code which says a person attempting to commit suicide is really committing an offense, and he could be taken in and then incarcerated. A trial could be conducted and then it could be incarcerated. Now, obviously, if a person commits suicide, if he commits suicide, there is no punishment possible. You don't punish a dead person. But if he survives that attempt, that is when the whole problem comes. So now there was therefore a movement that a person who wants to take his life away ought to have liberty to do so. They were trying to say the Constitution guarantees to you a right to live. Why not a right to die also? It should be the converse. It should be just the other side of the coin. So if one is permitted, the other also ought to be permitted. So there were pronouncements on that also. So therefore, it all started with the suicide issue, whether it is legitimate or not. And two important decisions came one after another, all of which had intimate connection with how the doctors treated. One was Aruna Shanbag, where there was a person, Aruna, a nurse from Kerala who had been working in Mumbai. She had been, when she was working, one of the ward boys was there in the hospital. He committed violence on her body. At the time, she was tied to the bed, and after the violence on her body, she was bludgeoned, and she went into comatose state. She remained there like that for nearly 30 years. When a journalist came into the court and said, "No, this is not fair. Why don't you allow her the dignity of death?" So therefore, that was an important pronouncement which came. And it said now the court can't do, the hospital can't do anything. There has to be a legislative intervention. That is what the Supreme Court said, making a reference to Airedale versus Bland. This judgment, was it correctly decided? Was that the right way? Cannot the court do something about it? And that is where probably the common cause was the case which Vidya was talking about. Dr. Vidya was talking about it, of a judgment in March 2018. That was the judgment in common cause versus Union of India. This was engineered common cause had amongst the trustees, the prominent trustees, Arun Shauri's father. He was an active person, socially very active person, legally very sensitive. So he has brought several important issues before the Supreme Court. He brought a case, and the prayer in the writ petition was, every person has a right to die with dignity. This is assured under Article 21 of the Constitution. And therefore, grant the right to die peacefully and with dignity. Declare that such a right exists and constitutionally protected. This was the prayer. And it was in this case that we have the issue relating to advance directive, the living will. So this is the background. I've set the whole arena for you to navigate the conversation of where your doubts would be, what more would you like to know, and how is it possible that we enforce this judgment? What are all the difficulties that you periodically face? How do we get around it? Can we get around it at all? Do we require a legislative change? Do we require an intervention immediately? How we as medical bodies, how do we lobby for something which is very important? And that is how I would see the whole argument is emerging. So thank you, Dr. Vidya, for giving me this opportunity to make the beginning, to start with giving you a context of how this topic could be understood and addressed. Thank you.
Dr. Yash.
Thank you, Dr. Vidya. Thank you, sir, for this very good introduction to the topic. I will start the ball rolling. The problem is with the acceptance of death. At times, we in our haste and we as intensivists and other professionals to prove that we cannot go wrong, we fail to understand that the patient is at the deathbed. Sadly, many doctors also do not communicate death very, very clearly.
You got muted, Dr. Yes, you got muted.
Yeah. There is a dogma attached to the word death, even amongst healthcare providers. This dogma has to go away. Second thing is what has happened over last few years, especially last 15 to 20 years, as corporate hospitals have opened up, paying capacity has increased. The patients and families are not able to accept death after spending a lot of money. Many of them, not all of them, many of them. So there is a gap in the understanding, one side amongst the patient and the family, and there is still a large amount of hesitance on part of healthcare providers, administrators, to speak about death. They are still very, very skeptical and tight-lipped to speak about word death. So this becomes a problem. How does the family takes it? Till the time everything is going right, they think everything is being done to improve, and probably we'll see the other day patient will come out of the ventilator, will patient will walk out the ICU, but seldom this does not happen. That becomes a tussle point between the family and the healthcare provider. The family suffers on various fronts. They have an emotional injury. Many low middle income groups and many rich families also, they go bankrupt, and probably bankruptcy in today's scenario, one of the major causes hospital bills. Third is the patient himself suffers when the writing on the wall is so clear that the patient is about to die. But in our zeal to treat and in families' zeal to overcome the distress or to overcome the disease, we fail to reach a common ground, and the patient keeps on suffering, the bills keep on piling. Neither the healthcare provider nor the patient or family members have any bad intent most of the time. So we are not ill-intended, we are trying to do it best for the patient. But somehow that is not accepted amongst healthcare providers at times and amongst the family. So we'll start the first question from here. I'll request Dr. Vasanthi also to pitch in, and Dr. Kannan sir and Dr. Vidya. How to make that acceptable?
Yeah, I would like, what I would like to say is, the minute you're born, you know you're going to die sometime or the other. So that's no issue at all. It has to happen sometime. And yesterday, when I was talking to a family friend who knew something about this living will and things like that, he brought up something very interesting, and he said how in above 50 years of age, people do not have, only less than 10% of them have a sudden death. Invariably, most of us have some kind of a chronic illness, right? It could have diabetes, hypertension, we could have any of those things. So at that point of time, we know we are going to die. So when we are in a good mental state of mind, why don't we think that we are going to die sometime or the other, and we have the right to choose and say, okay, this is what I want. And I'm sure nobody can kind of stand in your way. And I don't understand why we need to, first of all, it may sound as a very silly question, but first of all, I do not understand if I want the right to die because of my illness that I have, why should I not be let to die? Why should there be a law? Why should there be a lawyer? Why should there be a judgment? First of all, I have the right. So that is the one question which I really want to put up to Sir, Mr. Kannan, please. Can you tell me this, please?
So you are mute, sir.
Your mic.
Why should this be an issue at all? It is as simple as a person wanting to die. And why do you not allow a person to die? This is the fundamental question which you are raising. it has not really seen it. It has not been seen like that. You can create anything with all your abilities. You can't create a plant. You can't create an ant as small as that. Anything which is living, it is understood to have a kind of a value which is immeasurable. So if that has not been in your hands, there is a famous Tamil song. I didn't ask why I was born. It was Kannadasan's lines. So therefore, I simply arrived without my asking for it. So do I take my life at any time? Can it be like that? So it has been a philosophical question. It's not merely a legal question. So generations of people have come to question that, make enormous discussion about that. In fact, I've been watching with avid interest a lecture on Sri Ramana, Bhagavan Ramana. All the question is about he experiences death when he was very young. And that's what gives the whole rest of his life meaning to himself and to others. How do you cope with death? So therefore, it is an important thing. The death, can you simply take away? It is seen, it is not to be easily taken away. And if there is one topic which comes with enormous concern and public debate in one of the most civilized countries, we call it civilized in the United States, is the issue of whether a person has a right to terminate the fetus. Does the child there, the fetus, does it have a right to be born? Or can a mother who carries that, can that person decide by exercising an autonomy to take the life away? So therefore, when the life must end, who can prolong? If there is a doctor's duty to take care of the sick and to ensure that the best of attention is given to make the person live, as certain as death is, but you don't let that happen very easily. That is again perhaps a conceit. This is again Paramahans Ramakrishna would say that there are two occasions when the God smiles a lot. One is when two brothers fight. This is my property, your property. Another is when the doctor says, I've cured him. So therefore, it cannot be somebody gives life, somebody takes it. For persons who are non-believers, it's still fine. That life is precious. Everyone understands the life to be precious. And therefore, how do we let that life remain the maximum time? And the doctors believe, it's a kind of a challenge. I'm sure if you have performed a surgery and you have it's a successful heart surgery, any doctor comes out, probably anesthetist comes out to say, yes, you have performed a great job, don't you? So therefore, it's a challenge to let a person live continuously. To prolong that is a challenge, and that is taken as something relevant for our existence. And that gives meaning to us. That we saved somebody is again something extraordinary. Can we not be saying there is a huge flood, somebody is getting swept away, and someone there swims across and then catches hold of one person and then makes that person survive? Is it not possible to philosophize? That was a time for him to die. There was a flood happening. So many people were dying. At the time when he was born, he knew he was going to die. Why help him out of this kind of a situation? We don't say that. We, on the other hand, find merit in an effort to make the person survive a catastrophe. So therefore, when we talk about why this issue, why should there be a judgment? Why should we be talking about dignity in death? In fact, this question has been raging in almost all countries. All the states in the United States, 50 states, all of them have dignity in death legislation for them. All of them are concerned. A country which is troubling itself. Now, Roe versus Wade is likely to be even upset by a conservative Supreme Court. The composition is conservative now. And therefore, 6-3 could be the reversal for Roe versus Wade on an issue of abortion. Now, this gets to be important for us because life is important. Prolonging life is seen as undertaking a challenge and redeeming it. So that is the reason why it gets to be talked about, why there is a law on the subject. Vasanthi.
No, the reason I was asking that was we need to have dignity in death. That's what I'm trying to say. We need to have dignity. And we know, suppose we're having a terminal illness, we know that we're going to die at some point of time. Look, I've had a incident where a person was 94 years old, had malignancy, had secondaries, and he was on a ventilator, and the relatives would not allow us to take him off the ventilator. They said, let him, I'm sure he's going to survive. And when we know 100% he's not going to survive. So that kind of a situation happens. It's basically because of a lot of finances involved. If the state is paying for it, right, or the insurance paying for it, then they're okay with it. But if the same thing happens when the relative, the son or the daughter or somebody has to pay for it, it's a very sad thing. You feel so bad about it. And they say, oh, no problem, doctor, I'll take him against medical advice. So that's the kind of a thing which we do not want to face as doctors. So that is something which is really very heart-wrenching. It really becomes very sad. You feel very sad about it. So that's what I mean. That's what I was trying to say. Not because we don't want the law or something like that. It's just that we need to have that dignity. And any of us would like to actually die at home with in peaceful state. It's not possible for everybody. Somebody is lucky to do that. If that happens to somebody, they're lucky. That's all. So other than that, then it becomes difficult for everybody. It's not just the doctor or the patient. It's the whole society. And that particular ventilator or that particular thing can be utilized for somebody whose life can be saved. So that's all there is to it.
Dr. Mohan Rao has a question, Vidya.
Please unmute yourself, sir.
Hello.
Yes, sir. We can hear you.
So can I ask a question?
Yes, sir.
See, as a doctor, I have seen too many patients being saved or made to live for unduly long time using various life support measures. Of course, doctors are supposed to save life, all right. But now I feel oftentimes these gadgets like ventilators are being overused. A patient is kept alive like a vegetable for a long time and made to suffer for very, very long time. At that point of time, the patient himself naturally is not able to decide what to do. And the relatives are in a dilemma. They are not willing to allow the doctors to stop the machines because of their emotional factors. So I think a person should decide well in advance whether he wants to be put on these life support measures or not. And this is, of course, a living will should be made. But currently, the living will is very, very difficult legally. A lot of formalities are there, very difficult to make it. So I, for one, would vote for a living will written by a person when his mind is completely sound, and also stimulate his relatives or motivate his relatives, son or daughter, whoever it is, and clearly tell them, look here, I don't want to live on these life support measures. Allow me to go peacefully. And if at all any life support measures like ventilator is to be put, please do not use it. Please allow me to go peacefully. Is such a will written in ordinary hand and properly witnessed and given to your children who are also signed in that will, is that valid? But I feel even if it is not valid, if you motivate your children and tell them your wishes, I think they can always say, please do not use the ventilator for my father. Is it okay legally?
Dr. Mohan Rao, I would reframe your question to Justice Kannan is how exactly does one go about preparing a living will?
Thank you.
All right, I'll take the question. I understand what, thanks, Dr. Mohan Rao. I should recall for you an experience which I had a couple of years back when I was in Chandigarh. Amongst the persons here, probably there are doctors from Chandigarh as well, and I don't know whether they were there. This was a meeting at the Punjab University. The PG Mer former director, good old gentleman, probably the most respected person there, as a person who had carried enormous value to the hospital services. So therefore, he was stone deaf at the time. He was well past 90. So he came to the front row. That was after I finished my lecture. It was your morning lecture. So I was addressing doctors in the Punjab University. And he said, I don't hear what you have been talking, but I came here to explain to you a problem which I have. I'm an old man and I've been a director of this institute. If I want to die, I want to die in peace. My children are in the United States. My doctors, my colleagues, my junior colleagues, my students who have been famous doctors now, I'm worried that they will not let me die easily. How will you assure to me that I can die easily? Then he said, oh, please send your answer to me by email. I can't hear what you're going to be saying. This was something about a doctor expressing his concern and worry that even if he chooses to die without any intervention, that he doesn't want his life to be unnecessarily prolonged by needless ventilators and prolong it for a long time, that you should be allowed to die. His concern was there are persons who are not going to make it happen. So therefore, this is the concern. And Dr. Rao, you also made a reference about how there are so many people who have difficulties. The poor people are losing money in these kind of resuscitative measures which are being administered. That cost a lot of money. Why do we need to do that? It's also a concern which you asked. And to take the last one, what is a will? How do you make that will? Let me tell you just this. Will, by the very nature of things, operates only on the death. So therefore, what do we understand by a will? A legal instrument which is written by a person who is mentally sound. He understands what he is going to be doing. And it will take place after the lifetime. So therefore, the last word is invariably, this instrument will take effect after my lifetime. In order that a will is valid, this has to be done. When we are using an expression like a living will, we are truly using an oxymoron. A will cannot be for a living person. But then that is the best that we can still come out because it was an invention, a kind of a judicial invention in 1960 in USA, when they used this expression, living will. Justice Deepak Mishra and Kanvilkar, who had joined in that judgment, this was a 5-member judgment of the Supreme Court. They didn't want that. They didn't like the expression living will at all. They said, we'll call it advance directive, because they were probably, as a typical legally trained mind, why use an expression for a will for a living person? How does a living person give effect to a will when during his lifetime itself? Therefore, he said, no, whether we may not like to use the word living will, but we call it advance directive. But then in several other places, you will still see that expression living will. How is it written? It is written by a person in a sound disposing state of mind. It has to be attested by 2 independent persons. And the understanding is, these are all not persons who are interested in making a bequest happening, making his legacy to go immediately. That can also be there. There are children who would love the parents to live on, is one thing. That there are also some diabolical situations where somebody wants some premature death happening so that he comes by a big bequest. So these are also things. So therefore, this will must be by 2 independent persons who had, with whom the person who is an executant. The Supreme Court uses the expression executor, not a correct expression. It must be executant, because the executor is a different status of another person who gives effect to it. That is what is the legal understanding. It has to be by 2 independent persons. And then it should be taken to a magistrate, and he must also attest it. He should know. And this will, while in the normal case of things of wills, it shall be for in relation to disposal of properties. This advance directive or living will addresses only one situation. It talks about a situation of what would happen at the time of the end, at the time when he's critically ill, when he can't take a decision. He's comatose or he's unconscious. He won't be in a position to declare what is to be done with him. Do they prolong? Do they give any resuscitative measures? Or do we say, do not resuscitate this point? Will that be fine? And if that is to be done, should it be written in a way? And therefore, the person who writes the instrument will take the 2 witnesses to a magistrate, a judicial magistrate. Magistrate also sees, you understand what you've done? You are very clear about the fact that in the event of you slipping into a state of health and mind where you won't be able to give any directives to a doctor, this will be given effect. Do you understand that? Then he says, yes. Then the magistrate puts a signature there. And then this is to be, copies have to be made. It is one copy is sent to the district judge who keeps it in this register. And then another copy is given to the local administration. If it's a panchayat, if it's a district, then it's a municipality. So if it's a corporation, the corporation. They're supposed to keep this. So this is so many layers of safety is given in order that a person takes an informed decision as to how he's going to be treated at an appropriate time and given effect. So how is it to be given effect? We'll take it probably as some other question as we see. What happens when should the doctor act on this? What happens if the doctor refuses to act, or the hospital says, no, we'll give you treatment, or in a situation where the patients say no, so this will not be acted upon. Please, we want the resuscitation to continue. Don't withdraw any life support. We want that administered. What do we do when we have a conflict? There were all other things which have also been addressed in the judgment. But for us to know, an advance directive is that which is to be made in a will, which will be attested by 2 persons, and it will be also seen by the district magistrate, and a copy given to the district court.
So there's a question in this regard. There's a question, it should be on a stamp paper or a plain paper?
It can be a plain paper. It does not require to be stamped. Even a will in relation to properties or what crores of rupees does not require to be on stamp papers. It is merely, it can be a white paper. It does not require registration. The Registration Act, which is an enactment, a central enactment, which is used with state amendments as well. Registration is a concurrent list. It does not require registration. It can be an unregistered document. It can be, when we talk about registration here, we understand registration in the context of the magistrate having it, keeping it in the depository with the district court. That is the registration we talk about. The document does not require to be written on stamp papers, does not require to be registered also.
How long does this process take, please? Once you've written the will and you're going through this, how long does the process take?
I think of my death, supposing, like Ramana, if supposing it was 16 years, I think of death, and I make no intervention shall be made by any person to resuscitate when I go into a state of mind and body that I won't be able to take a decision. I can keep the document. That will be given effect at the time when I'm taken to the hospital, or when I'm at home, when I'm in a state where I'm not in a position to take a decision, and the doctor comes there to support, to make him, to revive his reviving. At that time, if there is a advance directive, it will be shown to him, because how will the doctor know unless there is a person in the house who is going to show it to him? So therefore, it will have an effect till the time he is brought to a state where he can.
No, that's not what I'm trying to say. I'm saying that living will, when you write the living will, and then you are going for the registration and things like that to the magistrate, and how long that process take?
As smart as you are. So it is that. If I can get a person, if I know a magistrate, I go there to his magistrate's office.
I know nobody. I don't know anybody. I know nothing.
You don't know anybody. So therefore, this is not a problem. What you need to go, you must know where the magistrate court is, so that you know where the magistrate is. So, and you're going to be, therefore, telling a magistrate, I've come here to declare my death must happen without life support. The magistrate will be wondering, why are you coming when you're going to die? So therefore, I don't want to do anything about it, is what perhaps he'll say. But then that is the way that the Supreme Court has said. This has to go through a magisterial process. Just not that. In a situation where you want to give effect to this living will, this will again go back to the magistrate. You supposing there is a situation where the patient's relatives are prepared to bring that living will to you and show to you, doctor, you don't need to give all those resuscitative measures. The person, my father wanted a death naturally, in peace and in dignity, doesn't want all his body to be poked through needles. He didn't want all wires running around his face. So please let him die peacefully. That man wanted dignity. We would respect his feeling, is what a person could be saying. You can't immediately pull out things, because the judgment now requires you'll have to go to the magistrate even then. So not merely for the execution of a will, every doctor must know, every hospital must probably find out where is the magistrate's office, Where is it? How do I approach it? What is the contact number? These are things which probably as doctors, we need, if this judgment has to be given effect and want to feed meaning into that, we need that kind of appraisal to ourselves. We need to know where the magistrate is, or you have to take it to that. The hospital board will make the recommendation saying, yes, there has been a will, so please come and take this. This magistrate, what you should do, you will escalate it to, it will come through the collector, then he will come to the hospital, he will satisfy himself. Is that man really in a terminal state? Is there sure method of knowing that this man can't take a decision? So therefore, that is the level to which he has to do, and that's when you'll be able to withdraw. So therefore, this process of making the will, the living will, and having it attested to take a day maybe. That's all. If you are smart, you can do that in a day. It can be several days. So therefore,
there are two questions, sir. One is there a template available on the internet or somewhere for living will? Second question.
What I can do, in fact, just before this meeting, I was preparing. I was somewhere anticipating that this could come. I would, this is a body of doctors where I see about 250 persons watching now. I would provide to you at the end of this session, probably, and circulate to Vidya who called me. I would want you all to have some kind of an instrument.
Idea.
This is something which we probably need to circulate amongst ourselves. One. Two, also to do what are all the things? What are the things which I need to know? Where is the magistrate? Probably there will be a change in
somebody wants to know why a magistrate is required.
See, there are several things. This morning, these are all probably some relics of the past. The way we gave dignity to certain offices. If you will know, for uninitiated to law, I can tell you, there are judicial magistrate and executive magistrates. An executive magistrate is a collector. You know, if there can be a shooting, you will decide. Law and order, you will decide. The executive magistrate, the collector, has that. They were all the British people at the time. The law and order was this concern at all times. A judicial magistrate was perhaps the highest in the lower judiciary. The higher judiciary is the sessions court. So the accessible judge was at the lower level, judicial magistrate. You lend a dignity to an office of a person who can take a responsible decision, help a person to ask the person, are you sure you want this? Is it unambiguous? Are you clear in your mind you would want any support system being administered when you are critical? These are questions which we expect a magistrate to ask. Why can I not ask? You may ask. So that is the reason why the judgment also says, this is all to be done, and the magistrate shall inform the family doctor. There is also an observation like that. So the attempt is that the magistrate is a person of dignity, and that dignified person gives appropriate counsel. And also for a person who takes a decision, if it is merely in the house and then slash it somewhere, you may not give effect to it. You bring an aura, you bring some paraphernalia to that, then there is immediately, it evokes a kind of a new understanding. Oh, it went to the magistrate. The magistrate was there, he called one by one. He was asking 100 questions before he signed and kept one register, gave one copy. So therefore, these are all things which can enhance the credibility to the instrument and evoke a greater sense of acceptability to the person who receives the instrument. To the members of the family, it can provide an additional weight why that directive must be given effect to and cannot be immediately trashed. That is the idea of giving it to a magistrate.
Dr. Girish, what is your question? Girish HC has been raised this and for a while. Please come here.
Yeah, thank you, sir. Thank you. Sir, I am a pediatric critical care physician, and we do end up with a lot of these end of care issues. I will just give you one scenario which I would not say commonly, but not uncommonly we see. And what is the best way forward? Because a lot of us actually still don't know how exactly to approach this. So this is about a 14-year-old boy who has a muscular dystrophy, and we know that his lifespan is probably about 14, 15, 16 years. He is completely wheelchair bound. Now he has come with a respiratory failure, and the parents who have taken care of him for last 15 years diligently do not want him to go through the ventilator and ventilation and end of life, dying on a ventilator. So they request us not to ventilate this child, not to put him on a ventilator, and let him die peacefully with all the relatives around. And as a physician, I do understand this is an end of life, 15-year-old, and that is probably he has lived his life and his heart is very weak. So a lot of times we do, I mean, having trained abroad, we have withheld care from this point onwards, and we have let them die peacefully abroad. But here in India, what is the best foot forward in this situation?
Yeah, thanks, Dr. Girish. Isn't it a simple thing of what you think, what your mind thinks, and what your heart, where your heart is, and where the parents also say they don't want the child to be put through all the ventilators. They understand that the child's life is fragile. Probably somebody has told them even at the time of his birth, when he was affected by this muscular dystrophy, that he may not have long life, and 15, 16 is what you would inform. And if we are not going to be doing that, if you're not going to be putting the child on any ventilator, what is the mistake which you're doing? Who is going to be asking you questions? In fact, none. If the parents also have your support, you don't need to worry. But that is not how the Supreme Court viewed it. It said, now, what do we do about situation? It raises a question like this. What do we do about a situation where there is no advance directive? Do we withdraw immediately life support? This is the question. Because this is somewhere ingrained in a doctor's mind. He literally takes about every situation where a patient presents with a very poor prognosis. How do I take it as a challenge and help this boy come over? So therefore, it is sometimes the medical exuberance which comes in the way of taking pragmatic decisions. So if you're fine, doctor, thinking that you don't need to give, and the parents are also not interested in prolonging it, the decision is made. It's all easy. But then the Supreme Court says, if there is a case where a person does not have a directive, especially when there is a child who can't take a decision, the decision will be a surrogate decision by a person like a guardian, the parent. Then in such a situation,
you got mute, sir. Kannan sir, you are mute, sir. You got mute, sir, Kannan sir.
Yeah. I suppose all I was saying didn't get muted. I was trying to literally conclude there on that aspect to say that if the doctor feels nothing needs to be done, nothing needs to be done. And if you have the parents and the immediate relatives also not wanting any life support to be given, that is the easiest decision to be made. So Dr. Girish ought not have a problem for a particular patient.
Sir, I have one more follow-up on this, sir. I have one more follow-up on this, sir. So basically what you are saying is, if the physician understand that this is the end of life, there is no hope. And if the parents understand there is no hope, they can give the advance directive in place of the child, right? Minor.
Correct. But you will not do anything. This was a question which was kind of flagged. We didn't take it further. What is euthanasia then? What is active euthanasia? What is passive euthanasia? I feel that there is a person who is suffering. It happened in 2005 in US, where there was a Katrina typhoon. There were a lot of people were uprooted from the houses. A lot of people were floating in water, suffering. And there were about 4 or 5 persons, members of the family, who had been in deep distress. They had their house had been submerged in water. Many of them were having breathing problems. And here is a doctor who came and saw them all suffering. And one of them has said, "Man, kill me. I can't stand this." So therefore, there is a doctor who said, "Oh, look at this man. This man can't stand his pain." And then looked at other members of the family. All of them are bad, man. Kill them all. I also want to get killed. So therefore, what this man did was, this doctor administered immediately medicines and then ensured that they had an immediate end. So this was seen to be a manslaughter of a degree lower level. You were not seen as there in US. You have situations of manslaughter of various degrees. Like in India, we have murder and you have culpable homicide, which is lower punishment you get. So therefore, where you do something to accelerate death, then probably you're committing an act which is impermissible by law, which is an act of euthanasia. You can't take a decision that let the man have peace. Let me accelerate his death by giving him an injection that can kill him immediately, some lethal dose. But a passive euthanasia is something which is different. It's passive only for persons who can challenge me on logic. Even when you're withdrawing, that is an act. Therefore, why do you say it is a passive act? It is still an active act. It can be somebody can be saying that. But to understand it from this perspective, that where you don't accelerate it, you allow a person to take the death coming in its own tide, then it is fine. It is passive euthanasia. What now the Supreme Court has permitted is only passive euthanasia and not active euthanasia. So if you take a decision not to do anything, it's fine. Though there are directives now, even this must be done with the hospital board coming to a decision. Yes, there is really a hopeless situation. You can't resuscitate this person. And then it has to again go to a collector who will say, give it away to a three-member committee of doctors who have 20 years of experience. Person must be in nephrology, could be a person in cardiology, or oncology. These are the persons who will constitute themselves with the district medical officer at the helm as the chairman. They will also say, yes, I don't think we'll be able to survive this person. They inform the magistrate comes and sees. They also say, yes, it can be withdrawn. Then it can be withdrawn. This is the procedure which now the decision expects you to do. But no sweat. You don't need to be doing all that. These are situations where there's going to be a problem. Yeah. Yeah, good.
Sir, I'm just, the reason I asked you this question is this, sir. So some of us who are old in the field and some of us who have been trained abroad, we are doing it, actually. We are doing it. But some of our younger fraternity is afraid that this is not allowed by Indian legal system and somebody may go and sue me and I can get into trouble. So that prevents them from doing it. So what do you suggest? I mean, what do you suggest? I mean, is there any, another question is there any precedence of somebody going later and suing the doctor for doing this?
Yeah, now I'll ask you, when all of you are here, has any one of you seen any one advance directive? Whichever meeting I've attended, I've always asked this question. Have you seen one advance directive? In fact, the counsel who argued this case before the Supreme Court is a good friend of mine. I was telling him, do you know what kind of judgment you made the Supreme Court pass? Not one advance directive will ever be given. Even the Mental Health Care Act, which talks about advance directive, did not think of so many difficulties, so many layers of authority and approvals. Why have we brought this kind of decision? So you were saying probably we'll have to approach the court again and then seek for a modification. This is impossible. This can't happen. No, if you have your younger colleagues who are scared and worried, you should only tell them, just that, see, document that properly, what you are doing, what you did, that you did not give something which could have survived. This is something which you will take a decision. You will say in your record that this was the person, he is brought with such a thing, we administered this, we administered that. So I know even at the time when a 90-year-old person, when he is dying, when he has a jaw breath, you still probably pump Deriflin or something into the heart directly. That's every attempt made before a person dies. So I know even that the child, God bless the child, he lives for several years more. But to simply take an example of a child whose condition is very bad, where you think nothing can be done. Say there's nothing, these are all the things which were done. The child died. Child died in this condition. There's no way it can be taken to court. No. And nobody goes to court so easily. Again, our courts are so difficult to approach. One, it can't take decisions quickly. So therefore, these are all, it's a big disincentive for anyone to be thinking of courts in India. Unless he has no other work, he doesn't go to court. Consumer courts are completely different, where the access is slightly relatively easier, and therefore you have a whole floodgate of litigations coming in. But I'm sure I must tell you again, normally consumer courts are favorable to the doctors. They see themselves as professionals one to another. There are also vague judgments which go out of the way. That is what gets to be reported in paper. Therefore, there is a kind of a phobia which develops for us. But by and large, they're not.
Yes.
I will just add 2 points about Dr. Girish's question. See, the futility in any case has to be objectively defined and it has to be documented in the records. Okay, second thing is, whenever we talk about intervention like intubation or ventilation initiation, we need to have consent, and the family has a right to consent for the procedure, or they do not consent for the procedure. Whatever they do, if they don't consent, that also goes into our records, and these refusal for intubation or refusal for ventilation will safeguard us in rare circumstances when a legal tussle happens. So document everything in black and white, have objective criteria. If the family is refusing by themselves, nothing like it, they can give it on a consent paper, on a blank paper also, that we do not want intubation, we do not want invasive therapies, ventilation, CPR, and most of the times we are following this only.
You're muted, doctor. I don't hear you. You're muted.
Yeah, Dr. Bala Ramachandran, meantime.
Good evening. I'm a pediatric intensivist in Chennai, and a follow-up question on my friend Girish's question. We are often in a scenario where we have a child who we have declared brain dead. Now, there are two questions I have here. One, what is the legality of withdrawing life support on this child, provided they are not going for organ donation? That is the first question. Second is, suppose we have declared brain death, but the family wants us to continue support. What is the legality of withdrawing support? The reason I'm asking that, it's in many countries, we do not need the family's permission to withdraw life support on a patient who has been legally declared brain dead.
Yeah, thanks, doctor. Both these questions are straightforward, and therefore I should have a problem about saying. What is the legal validity for withdrawal of life support? I said, now, if there is not anyone, the immediate relatives are not creating an issue for you and they have no problem, they are not insisting on any life support to be administered, then you're easy, that you keep all the records possible, it's done. But then I told you that after this judgment in March 2018, they confront in paragraph 195 onwards to about, this is a long judgment, 5 judges have written the judgment running to about 500 pages. It can tire you to read that. I'll therefore help you with where you need to be seeing, probably towards the end of paragraph 193 onwards of the Chief Justice there, Deepak Mishra and Kanvilkar. They have, this judgment is the central piece around which each other judge, Chandrachud for himself, Ashok Bhushan for another, Sikri for another, they brought different facets to the case. What are the economic considerations? What is the autonomy? How does it play a part? What is the legal, what is the philosophical background for this kind of thing? These were addressed by the other 3 judges. The central piece, however, was the Chief Justice who was saying, even in the event where there is no advance directive, the legality, if we are talking about strictly, will be to take it to the hospital board. This boy, I don't think he's going to survive. Would not, I will not give. See, you have not administered something to withdraw is going to be an issue. But when is brought in a critical stage where you think you won't be able to do anything, the person say, is the child too ill? You're not can't be doing anything. Please let him die. They would say probably there is nothing there. You can only say this boy was brought in such a condition. There was no possible. We tried injecting this. It couldn't be done. But then the Supreme Court says now you will have to take it to the hospital board. Hospital board will say, yes, this child is critical. There will be no purpose in administering anything of life support systems. There is no point. Then this is to be escalated to the collector who constitutes a committee. That committee will make a recommendation affirming the decision taken by you. Then it will go to the magistrate. Magistrate will come to the hospital. It will see, yes, what decision you have taken is also being confirmed by the collector appointed board, and therefore you don't need to do anything more. This is truly the legal situation in a condition where there is no advance directive at all. So therefore that is one. Second, a brain dead person where the patient's relatives would not want anything to be withdrawn. They want it to be continued. This is contemplated in this judgment. The relatives stating it has a meaning, because in foreign jurisdiction, if you say relatives have no role to say when there is a brain dead situation is contemplated as a situation which can even enable transplantation of organs. So therefore, it doesn't, of course, give the act again sets whose organs can be harvested, who could be a lawful donor, and when can cadaverous transplantations, when will that be possible? All that are governed through another legislation. But the point which we will know is that if there is a brain dead person and the patient's relatives want medicines to be still given, or they want the person to be kept in the hospital, it is for the hospital board to be constituted immediately, take a decision that nothing else can be done. They escalate it again to the collector. The collector constitutes a committee. They say, yes, nothing more be done. No matter that there is an objection coming from the relatives for a brain dead person for withdrawal of life support, you are in safe turf when you are playing it as per law. This is the way to go about. So that would the answer to you, Doctor.
At the present moment, even when you know there is futility of care, as long as the patient conscious relatives do not refuse, we have no standing for not initiating advanced care. Am I right in understanding that?
I'm not very sure I've understood your question.
So let me give an example. There is this 90-year-old patient with terminal cancer, but patient is not refusing advanced treatment. Relatives are also not refusing advanced treatment. There is no advanced directive that has been registered. So
how do you mean by advanced treatment? The patient is not refusing advanced treatment. Please explain what do you mean by that?
What I mean is, if he needs a ventilation or he needs intensive care, patient is not saying no.
Huh.
I know it's futile.
Why do you volunteer there? So therefore, what are you trying to volunteer? Why do you feed an idea into them? The person is malignant, is 90 plus, he is dying, he is going to die. There is no compulsion anywhere under any law that you need to therefore administer immediately put all support systems. It's not there. Your question, your ethical considerations are you don't let a person die easily. You will therefore try to revive. You take a decision. They say no. They don't say no. That's why I said there is already a procedure in law now. In a situation where there's no advance directive and you want to take a decision not to give anything, as per if you want to conform to the letter of law, there is now a procedure which is contemplated, a two-tier system. It talks about a primary consent, which is the primary step is to go through your hospital board, then to escalate it to a higher board and to the magistrate and to withdraw. This is the formula. This is the protocol which you will follow in every situation where there is no directive.
So unfortunately, many situations don't give us that much time. It's when patient is, really sick, we don't have time to go through this.
Correct. Therefore, is it not therefore foolish? Therefore, it is not. Is it not? Don't you find it to be a foolish dispensation? That I'm using this expression because I'm in a forum where I think I'm entitled to a liberal criticism of what I see as a judicial dispensation. Dispensation which talks about, as it is, anyone knows. 3 persons joining together, taking quick decisions. That quick decision is what? Then the person can even be, if you have an informed, proper decision, what kind of deliberation was there? How did you take this decision in 2 minutes, 3 minutes, 4 minutes? Why did you not take, how did you call them all? How did you not get them? If one person in the council committee was there traveling, he picks up a phone, you brief him on everything. Yes, I think it's fine. I don't think we'll be able to do anything. I've also seen you sent him a WhatsApp to the hospital record. He looks at it. Yes, I think this patient does not require to be any longer intubated. Leave him alone. Therefore, take it away. So then this is taken as a committee recommendation, goes to a magistrate. This is all going to take, probably the person will die by the time. You can still escape by saying, look, we set the process in order that we don't give by the time he died. So therefore, we have, our record was there, but before that was done, this person has died by himself. A person dying by himself, a natural death, by you are not doing something, is not even a case of passive euthanasia. We are talking about passive euthanasia in a context of something having been done, you later withdraw. That is where it is passive euthanasia. Supposing a person is brought in a serious state, you are looking there, you are calling the doctor, there is a young doctor who is trying to manage it, he is sitting in the emergency, he calls the senior, he tries to do something to resuscitate. The senior probably would have gone for a more aggressive approach. to get so many gadgets all fixed up and things. Or there could be other economic consideration for the hospital to do what they thought was remunerative. So pardon me for saying this, but then look at, these are all realities. And there is another doctor who didn't do. We don't talk about euthanasia in such a situation. The doctor, he tried to do something, before that he died. So therefore there is no question of passive euthanasia coming. You administer something, later you'll have to withdraw that. Withholding or withdrawal are completely different things. You withhold a particular treatment, it's a different thing of what you do. You did not do, then there is probably a suspicion that you did not apply a standard of medical care which was essential. This was in Bolam in 1957 in UK. Now that has also undergone a small change now through a judgment of the Supreme Court recently. We are adopting the fresh standard which the UK Supreme Court has laid down in Montgomery, where the informed consent must be such. You should be looking for every scope, everything, every factor which is necessary. You should say. Just one point. I'll say here. See, there could be situations where a person. Let us talk about a patient who is not too well aware of things. He thinks. Let us assume that typically in Tamil movies, you see cancer, even the word will be pronounced in such a way that it will spell death. So therefore, now we have known it is possible to administer treatment and give fairly some extension of life. It's possible for a person to lead a normal life also after a cancer survivor can have a normal lifespan. All that is possible by medical intervention. Supposing a person who is poorly informed, he doesn't know. He gives an advance directive, no treatment fee, no chemotherapy fee, and things like that, an advance directive. Then it is not necessary that you must give effect to that advance directive. The question would be, can I also not act as per the advance directive which is placed before me when the person is very sick? The judgment talks about it. That could be a situation where the person, if he had known something else, he wouldn't have taken this decision. Supposing it is like that, that person is still all right. If he's in a conscious state to understand, you can tell that person, you have taken a decision not to have any resuscitative measures in your critical state. You probably believed that this was too difficult, but this is treatable these days. So there is a time when you can, where that particular reason why he took that decision was on a wrong basis. You can explain that wrong basis. And if he still says, no, doctor, I don't want it, then you'll have to go through the protocol which I said. So therefore, there are also situations where you don't need to act as per the advance directive. Those are typically two situations where the language is inappropriate, ambiguous, you can't give effect to it. Two, it was not with a full understanding of what was possible, and therefore a wrong decision, not an understanding which is appropriate. Therefore, you took such a decision. That could be a reason why you will not give effect to it.
Dr. Mohan Rao, sir, if you can ask your question, are you there?
Chandrasekhar raises his hand.
Yeah.
Dr. S. Chandrasekhar. Yeah.
Sir, Chandrasekhar, sir, you can unmute and ask your question.
Unmute yourself, Dr. Chandrasekhar.
Kannan sir, meanwhile, I'll put a question to you. Means this living will is an open document which is editable in light of new evidence of medicine as per the family members who have been deputed for the same.
Yeah. All wills are in the very nature of things irrevocable. I should have a right to revoke it at any time. That revocation can take place after the living will is made and registered with the executive magistrate, with the judicial magistrate. A revocation must take place the same way as an execution is done. It is referred to in the judgment like that. Therefore, what I will do is I revoke the will which I have made already. See, in a normal will, a revocation can take place even by tearing it off. But this does not talk about tearing it off. It has to be written the same way. I've executed a living will on such and such a time, and I decided that no life support need be given to me during my advanced stage of illness and critical health. But now I modify my mind because I was under the impression that it was not treatable. Now I believe that I was not taking the correct decision. I can revoke it and then take it to the have it attested by two persons, witnessed by two persons. Take it to the magistrate. He will register it, keep that as revocation. So that is perfectly possible. Living will can be revoked and modified. and it can be changed at any time. But nobody else can change it. When he has become incapable of taking a decision, therefore we revoke it. The family members can't do that. Then in which case you are bound to give effect to it. And if you are bound to give effect to it and you have your family members opposing it, you'll have to take it immediately to the hospital board, to the board, the same 1, 2, 3, the formula which I said you'll have to go to. So therefore, the family members' concurrence is not at all times necessary. It is like this. See, when I say I'm offering my eyes to on my death, my eyes must be donated. The best practice is to inform your wife and children, because they are going to make it happen. After I die, I wouldn't know whether this is going to be let known or not. So I should tell them, take them to confidence. Please respect my wish at the last time. So therefore, I want you to know this. I'm donating my eyes to this. The same way, a person who makes an advance directive must take the family members to confidence. And that amount of activity, any person who must, any family member will understand that. There could be probably an emotional moment, but then it is done. I've known of a judge from Chandigarh whose family respected his last wish that his body be given for research to PGMR. And therefore, from the house, it went directly to the hospital. It was poignant for me to see that the hospital came to take the body away. It was not an orphan body, which is probably what makes our hospitals, mortuaries, makes it possible for our experimentation. Here is a respected judge who offered his body for research, and the family members gave respect to that, because he called his son and wife and said, now if I must die, don't cremate me, don't need to burn me, please hand it over to the hospital. So it is done the same way. Any revocation, any change, if it can be done, he should do it himself. Nobody else will be able to do. To give effect to it also, he should ensure the family members are fully informed. Yeah, Dr. Chandrasekhar now.
Sir?
Yeah, I see his hand raised, but he's not able to probably generate the question. So if there is anyone else on that.
Yeah, there's another Chandrasekhar. I don't know.
There is a question in the chat box saying that can a patient give it in writing while getting admitted to the hospital that if I get worse, I don't want to go to intensive care. Would that be valid?
Yeah, so that is typically a situation where I said after this March 2018, an advance directive takes a particular shape, a particular rigmarole which is there. So therefore, if a person gives it in writing, he's not literally giving an advance directive in the manner contemplated in Common Causes Union of India. He's merely expressing his intent. So it should be dealt the same way as though there was no advance directive given. If you don't take any action, if I'm going to a critical state, don't do anything, nothing will happen. That's what I can say as a measure of practical exigency for you. You ought not to be worried too much that there are courts there, there are problems there. This is a hospital which should be supporting all doctors. There are, however, difficult conditions which had an occasion to speak to the doctors in Delhi some time back. Was there are new situations where the family, they vandalize, they hurl stones. You didn't take care enough. So therefore, these are problems which therefore in the pandemic act, there were rules introduced that patients, family members and things, you can't vandalize, or the result, the ultimate result, if it does not go to help the patient to survive, the hospital cannot be made responsible. That kind of immunity provision and taking penal action, providing for punishment up to 5 years has come through a change in law. But they're not sufficient. There's still unruly behavior. These are to be dealt with extraordinary sensitivity. I think anyone immediately on losing a family member, if they are under a perception that they were not properly taken care of, there was nobody attendant there in the doctor. These are situations which must be handled with enormous care. Ensure that the hospital does not take more than what they can really help the patients with. Ensure that there is everyone who is there goes through a kind of a drill in the morning, is sufficiently motivated, that they are there to serve, to help. So therefore, not be somebody says he's in pain, that's how it will be painful. Make the person say, yeah, we'll come there, just place the hand or something. This is probably everyday reorientation may be necessary. After some time, you get used to certain type of things. And therefore, I'm told by a doctor from Mumbai as to how in the maternity wards, what type of things are stated and how even the nurses speak to persons who wail. I've heard about that. Not very pleasant. After some time, you get used to it, and therefore, if somebody wails a lot, you ask that person to shut up, saying something very profane. So therefore, these things happen. But let us bring sensitivity to our behavior. It should work.
The Wing Commander Arun Kumar. Please unmute, sir.
Yeah, I'm here. Thank you, sir.
You can put a camera on.
Yeah, I'm sure. Yeah, I'm on. So, sir, I just wanted to know. I mean, I think there was a wonderful discussion. What is the lack of legislation, which was mentioned right at the introduction? How much it is impeding registration? Is it unless it is there, it is not going to happen, or what is it exactly?
Yeah.
How they are connected?
In our constitutional scheme of things, there are things to be done by the three wings of governance: the executive, which executes the policies; the legislature, which legislates law; and a judiciary, which adjudicates in issues relating to conflicts arising by the application of these laws. These are all certain things. But the Supreme Court in our constitution has a provision that what it states is the law throughout the country. So therefore, apart from a legislative exercise of what the parliament may undertake or the state assemblies will do, what the Supreme Court does, it is not about every high court. The Supreme Court can lay down a law even where there is a legislative vacuum. This happened in sexual harassment case for the first time. They refer to it as Vishaka guidelines. What happens if there is a woman who is sexually harassed by somebody who is superior, and what is the redressal which is possible? There is no law there on that subject. Therefore, the Supreme Court framed guidelines as to how there shall be a committee constituted. If there is a redressal mechanism, how should it address? What type of punishment is possible to be administered? All that was given. Then later we have now the Sexual Harassment Prohibition Act, later coming sometime in the year 2013 or something. So therefore, till that, the Supreme Court judgment, they pronounced a judgment like that. This will exist as a law so long as the parliament does not pass it, or the assembly does not say that. Because the reason is, every institution must recognize their own limitation. Yeah, Supreme Court, merely because it is supreme, cannot take away the functions of the parliament. That is a function which is a representative government who are responsible to the people must legislate. The Supreme Court judges are not responsible to people at all. They are not elected by the people. They get to be selected for umpteen reasons. I can't now go to that. So that's a different topic. So therefore, they will stay within their own realm. It's important. So in this, originally in the judgment in Aruna Shanbhag, it relied on Airedale UK case in 1996. And they said a matter relating to euthanasia, there must be a legislation of the parliament. The courts can't do that, is what they said. And Markandeya Kajju, who was the author in Aruna Shanbhag, he belongs to that school of thought that division of powers, he wanted to be very strict, that courts will not do anything which the legislation must do, is what he was convinced about. Therefore, he applied that and said that is what should be, that is what is correct law. The Supreme Court in Common Cause said, we are guided by different considerations. Vishaka guideline makes it clear that when there is a legislative vacuum, Supreme Court will create a law till that is substituted. Therefore, we are now setting out a law. We discard Aruna Shanbhag's dispensation that only the Supreme Court must refer to, only the Parliament will legislate with reference to euthanasia. We legislate now till the Parliament comes with a law. We allow for passive euthanasia, because they were considering at that time how the trend has gone. almost in all countries, except in Tasmania, probably in Australia, all the states have euthanasia, passive euthanasia. You have all the 50 states having passive euthanasia through law. All legislation, all state legislations provide for dignity in death, because they see in India privacy of what I say, or autonomy. These are aspects which came through important pronouncements later. One Justice Puttaswamy, judge from a former judge from Karnataka, had filed a case in the Supreme Court. That decision recognized the right to privacy. It was in the context of Aadhaar, to what extent your biometrics and all things can be accessed by the government. There they went into expansive understanding of privacy, and took also euthanasia as an expression of where a person wants to be treated in a particular way, wants to die a natural death, shall not be administered with something, and passive euthanasia is acceptable. This is what they said. So therefore, there must be a law for that. See, without a law, that you have so many difficult provisions of what the judges said, because they're overacting. If there is a responsible government, they'll be doing what they did in the Mental Health Care Act. In Mental Health Care Act, you have section 6 and 7, 5, 6 and 7, which talk about advance directives. Section 6 is very simple in its context. It says advance directive is an instrument made in writing by a person who understands what he is doing. Then he can do in a normal state what can happen during the stage when he's going to die. This living will has relevance only in that. It has a relevance only to how he will be treated or how he will not be treated when he is going to be in a critical state, when he can't take a decision, when he can't communicate. So these are things which must be stated in law. It should come through a law. It has not come through a law by the parliament or the assembly. Therefore, this issue. Why is not a law? Why is the law important? Law is important because laws ought to be formed only, to be legislated only by the parliament, our representatives, or by our state assemblies if it's a matter relating to health. Is a state subject as well. It's a concurrent list, and therefore state can also legislate. And we need a law from the respective states which will take an appropriate decision which is working. So you are not the doctors, you are the stakeholders, you are the persons who are seeing life and death every day. You should be able to lobby for an appropriate legislation. You should be through your bodies say to the parliament, to a parliament makers, make a representation to the prime minister. Probably now they are all distracted to COVID work, but then this is essential. So many things are done only by mailing, by making persistent demands. We say in a Tamil proverb there, which says now only a wailing child gets milk. Same way, only if you wail, if you shout, if you make your presence felt, you won't be taken seriously. Make that happen. It is essential. This is not a unionist approach to life. This is essential. This is the way.
Dr. Bhavna Patel.
Sir,
Yes, sir.
one minute, sir. 1 minute. Just a follow-up of the simpler question is, then why is it that, like we said some time back, that this registration, probably zero registration is there in the country?
It's so difficult. The Supreme Court judgment is so difficult in the way they say. You take it to a magistrate, you go to the way it should be given effect is impossible. Making a will is not a very difficult thing at all. But to have it through the register, a magistrate will not see you at all. There is half the days he will be not available. He will have other work. You will have a dafedar standing outside, say no, the magistrate doesn't want to see you, get away. So therefore, these are all the realities. They don't understand. Today, I was some doctor who is taking a research position somewhere in the central government wanted a certificate of character from a magistrate. That's what is the government order. And I was approached whether I could get that. I don't know, the person could be there probably also watching the show. I was saying it is not possible for me to secure the signature from the magistrate, but I can secure the signature from the High Court judge. Is that all right? Is the question which I said. High Court judges can be easily approached, not a magistrate. So therefore, that is the issue. So
thank you, sir.
Yeah,
thank you.
Bhavna Patel. What's your
Hello. Yes, sir. I want to ask if someone don't want to write in detail what they particularly want in advance directive, but just want to write that who will take the decision in the case he or she is not able to take his own decision. Like,
Yeah,
for example,
yeah, I understand, Bhavna.
Healthcare by proxy.
It's a beautiful question. Actually, that makes a difference. This is something which I probably omitted to say. One is the advance directive through a will, a living will, is the manner of how that person must be treated. Now, what she is bringing is something which is different. This is a medical power of attorney. This is a medical attorney. That is, who takes decision on my behalf? Who is the surrogate decision maker? That can also be made. It is done the same way. It is to be written on a document saying that this person, in the event of my illness, this person will be the decision maker to what must be done. He may take a decision to withdraw support. He may direct it, further treatment to be given. All that kind of things can also be done. This is also dealt with in this judgment. Therefore, apart from a living will, this medical power of attorney is also recognized, and it is to be done in the same manner. It would require to be done the same way with two witnesses there. Normally, a power of attorney does not require any attestation, but to evoke confidence, to bring a greater sense of authenticity to the instrument, it has to be done and attested by two persons, taken to the magistrate, and then he countersigns, keeps one copy, gives another to you, yet another is sent to the district court. So that makes a difference, and that decision maker will be the person who will be the surrogate decision maker for what he does, what an instrument, a living will does, instead of a living will operating in a self-contained manner as to how it should be done. You have a human agency dictating how it should be done, how the person must be treated. It is possible.
Dr. Pushparaj.
Yes, sir. Good evening, sir.
Yes,
good evening, sir.
Yes.
Sir, can you enlighten about DNR, do not resuscitation, in terms of law, which we generally do in critical care areas? Even we ask to attendant, or sometime attendant asks for the do not resuscitate or do not intubate. Does it exist in our law, or is like further our solution?
Correct. Actually, Dignity in Death Act was there in Oregon. That probably created a kind of flutter at the time. For that was perhaps the first legislation in USA amongst all the states, as to make possible for a person to die peacefully and to keep a card, do not resuscitate. This was also a religious belief under certain Christian faith, where the transfusion is not acceptable. So the blood is so important. It is there. What Jesus shed for the sinners, or what he sheds, the blood cannot be spilled elsewhere. It is to be only with you, and it cannot be transfused. So therefore, there are certain situations where there was a practice before the law came of persons declaring do not resuscitate, which are called as the DNR. So the Dignity in Death Act of Oregon provided for DNR, and several legislation therefore talked about the DNR as a method of advancing one's interest, of one's intention of what should be done. In India, it was perhaps, I'm not too sure, that was never practiced. I don't know whether any one of you doctors have seen in India a person holding a DNR card and then somebody pulling it out or saying, oh, there is a there. I'm not too sure. It is perhaps not prevalent. But then DNR is another manner of saying, after this judgment in 2018, that advance directive is required to be done only in a particular manner. If there is a DNR, I will take it to be a situation of a person not having an advance directive, and therefore must still be approached the same way. You'll have to have a hospital determining whether critical care must be given or not, whether it can be withdrawn or not. So it's a kind of a thing which probably will go into our mental thinking. The hospital authorities may probably think, even the man doesn't want anything to be done if you hold the DNR. So your propensity to take a decision in favor of withdrawal will get enhanced by the fact that you are aware of what he has. Though it does not have legal sanctity itself, but an approach will still be done, which will make possible that do not resuscitate to come into effect. Then this can get, probably it has to go the same process. I'm not going to be repeating. So DNR is not legislatively it's not there. This Supreme Court judgment, they do not make possible advance directive to be done in any other manner than the way they have prescribed, and therefore that is the way it can be approached.
Yeah, Dr. Nalla, please come in with your question. Nalla. Are you there? Yeah, Dr. Girish.
Muted myself.
No,
Hi.
Hi,
Patta.
Yeah. Nalla, yeah, carry.
Yeah.
Dr. Girish here.
Just a minute, sir. Let Dr. Nalla come.
Yeah. Okay, sure.
Yeah. I just wanted to share something very personal that happened in my life. Now, when I got married to my father-in-law was very specific of one thing.
I want to see the other.
He was asking about why, when he said, when I get disabled, I don't want to suffer. So I want to die peacefully. So being an anesthetist, he was requesting me that give me a peaceful death. And he went on to say that he will write a will telling that my son-in-law, who is an anesthetist, can give me this peaceful death. And he went on to research on this. And then he found out that he was telling why your Hippocratic oath, which is saying that you will take a oath to save the life of a person. Now we have come to a stage that you should also have an inclusion of, you will also give a peaceful death to somebody who's suffering. So this was something that baffled me. So he went on and he researched a lot. And then he went on to say that he looked at that absolutely true. There are a lot of states in the world that legally allows euthanasia, but then many of the countries don't. So the question is, a legal euthanasia should be allowed, one. Two, the laws should not be so forbidden. Like I work in Middle East. You know what is the law here? You cannot, there is no DNR. You have to wait for the heart to stop. So we have patients who have been on ventilator for 10 years, brain dead, but because the law said we will not accept anything until the heart stops. Until the heart stops, the doctor who is attending to the person should continue to do whatever possible.
Dr. Nalla,
otherwise you'll be put in the penal code. You'll be charged in the court of law.
Dr. Nalla, I'll just intervene there, interject to say this.
Yeah, can give me some idea.
Yeah, we are literally talking about an important legislative policy. I began with such statement that the issues of life and death are philosophical, not necessarily medical, not necessarily legal. Where you go into a realm of further deeper analysis and reasoning, we talk about that as philosophy. That's why we say Dr. Philosophy, a PhD goes deeper. It's at that level, it's philosophy. So therefore, and philosophy is not science in that sense. Not necessarily it should give itself only to one answer. There can be several answers for that. So therefore, allow me to die peacefully is one way. What is possible in this country where there are several children, the population is large, where there is not the human values systems are very different from how they are there. Holland has this. Holland has a case. You can go to Holland and tell the doctor, I'm leading a miserable life, give me death. They will give you death. In 1 year, there were more than 10,000 deaths. United Nations was panicked. So what is happening in Holland? Let us go into a better audit. This is not correct. We can't allow this kind of people going to a country to die because they are unable to cope with life. This is not the way. A state policy should it be done. So there is a very thin line drawn from that active assistance to death to another person. You die only because you don't want to prolong. I already gave you an example of what happened in USA. Of see that it happened. It turned out to be a racial twist also. The doctor who administered lethal doses to the persons, all of them were Afro-Americans, all of them were blacks. Would he have done if they were all whites? Was the question which was being asked in the court. So therefore, these are tough things. Whether a person must die, allowed to die. I also told you about how a doctor in Chandigarh, a prominent doctor, was worried that his colleagues will not let him die easily because he had been a director of the hospital. So these are concerns. But right now, there is unanimity around along the world community that passive euthanasia is possible. But active euthanasia, to put an end to suffering, that's a tough call. We'll still have long more years before we can come to such a decision. I see from one person here asking a question: what happens if the hospital they don't give the bill? They want further treatment to be done. How do you carry with things like that? To quickly answer that, no hospital. It happened sometime back in Calcutta, where a person was found in a terribly injured condition. Somebody, an onlooker, he takes him to the hospital. He brings the person in a seriously mauled condition, says, "Now, please, doctor, take care." The person in the hospital says, "Now, deposit money with us." Or, "Who are you?" He says, "I'm merely an onlooker. I've come here. I'll inform the police." Then they say, "Please take the body away. We are not going to be doing anything." The person was taken away, and within a few minutes, he died. Their family brought a case against this hospital. I'm not naming the hospital, nor am I naming the doctor. But then it went up to the Supreme Court, and the National Commission originally slapped a fine of 10 lakhs against the hospital for insisting that the amount must be deposited before any treatment began. Now, even in the Clinical Establishment Act, which was a model legislation with the center passed, and which several states have accepted that. Even Tamil Nadu, you have a Critical Establishment Act. No hospital can, even a small clinic cannot deny treatment if it's brought as an emergency. But should be compelled to be expending for the person even without the hospital money being given? Probably or not. So nobody is running charity right through. So only ensure that there is no ethical violation. You have done your best, and it is not possible to administer more. Get some injection which is there, which I'm going to be bringing, or you purchase the medicine for 10,000 rupees and giving it. It may not be working. So therefore, you will not be faulted like that because even the Consumer Protection Act requires only a treatment which is there for consideration. A person can complain of deficiency in service. So therefore, no hospital is expected to treat a person freely, but you will not make it as a precondition in an emergency situation. That is all we need to know.
Yeah. Dr. Girish, a short question, please.
Yes, sir. This is actually a continuation of the previous question I had asked. A similar, same 14-year-old with a disease where there is no hope, and he comes in the night, and emergency doctor because his oxygen was coming down, he puts him on the ventilator. But morning, the mother and father who have taken care of him for 14 years, they know that there is no hope. They want us to withdraw ventilator, and we also believe that that is the best thing to do. Then does the law differentiate between withdrawal of care in this situation versus the withholding of care?
Yeah, there is a difference. There is a doubt about it. There is a difference between withholding of care and withdrawal of life support.
Withholding so in this particular scenario, sir, can we do it? If the
see, you are talking about something where there was already a ventilator and things you had to be withdrawing. You're not talking about withholding in such a situation. We are talking about withdrawal. So withdrawal, if the parents also say yes, withdraw, if we have nothing. Now I told you, even in a case where the Supreme Court now says even that must be approached only in the same way as though there is advance directive is what it says. Therefore, if you have to conform to law, if you have to withdraw support, you have to set up a hospital board to recommend withdrawal. Run through this process very quickly. That's what you should do. Get 3 doctors at the hospital, nominate the 3 doctors who say now this person is in a very poor condition, withdraw support. Send it to collector. Collector probably may not even do things. Follow it up. You must have, any hospital must have a PRO who is able to take that kind of initiative and ensure that these are all done. If you want to stand for law. But I tell you, so many things happen that you wink at law. You ensure that you have the immediate parents supporting your decision. They want it that way. It will not escalate. Don't worry. These kind of things don't go to court at all times. If there is something to be changed where you find these kind of directives which have been passed by the Supreme Court to be exceedingly onerous, it is for the hospital managed establishments, and the doctors as a powerful lobby must be able to do something. Now we have a national commission.
Sir, last one, sir.
I won't be able to satisfy you at all.
No, sir. There is only one question because I think somebody else also asked this question in this thing. In this situation, if we believe as a doctor that there is no hope, and the parents want to withdraw, and we withdraw, somebody asks some relative or some neighbor just for creating ruckus, can they go to court saying that this was illegal?
There is something called as a locus standi, Dr. Girish. That is, the person who makes a complaint must be a person who is interested. This is a primary victim must be the person who has died, and the person who is entitled to claim damages must be a person who is the representative of that victim, of that patient. So therefore, they are normally the legal heirs. The legal heirs are depending on the personal law to which they belong. They are the parents, they are the sons and daughters, they are the relatives are there. It is like that. But a secondary victim to also claim damages, it is not recognized in India. It has come in one judgment from the National Commission, which went up to Supreme Court. It is a Spring Meadows Hospital case from Delhi. That was a case where a nurse administered a medicine, a wrong medicine, to a person who had some gastritis or something like that, a child which had a problem where the intestines had been affected. Some medicine had been given, the child had been rendered to a comatose state, and probably still lives in a state like that. There they awarded compensation for the patient as well as to the parents. That was the first time when a secondary victim was also granted the compensation. So normally your question must be answered simply that others can't come to court. The Consumer Council on behalf of the affected party can do. The affected party can only be a legal representative. Legal representative has a legal connotation of a person who represents the estate, who has a right to expect something. They are invariably the closest relatives which the law recognizes. Others can't do anything. If the parents have said nothing to be done, nothing to be done. The others can't take you to court. That's the answer.
Rasika Madan.
Yeah, Rasika, I see your hand.
Padma Priya, please. Unmute, please. Unmute and ask your question.
Yeah, this a very nice topic, sir. See, I'm a neonatologist, so we deal with. Am I audible?
Yeah, you are.
Okay.
Go ahead.
I'm a neonatologist, sir. So we deal with small babies, preterm, premature babies. So now, as you know that there's no question of will. My question here is about the extension of what Dr. Girish was saying, withholding support. Sometimes as the period of viability is going lower and lower, people are saving 20 weekers, 22 weekers, 23 weekers. But in India, there is really no legislation. We still hold the thing of up to maybe 26 weeks of gestation of a baby. But if somebody is born much earlier than that, and if we feel that the outcome is not going to be really that good for all the financial this thing that they're going to take up, and the outcome after giving an explanation to the parents, is it okay that you withhold? I mean, in the sense you just give them what you call a simple. I wouldn't call it.
I've understood your question, Dr.
Yeah.
Patta.
Is it
See,
okay to withhold or just say? Sir, let me just complete, sir. Can we say that for us we have the period of viability of we don't resuscitate babies less than 25 weeks. Maybe some other hospital does. Are we justified in doing that by the court of law, or is that it's just bound by the parents' wish and you go ahead?
Don't bring the parents' wish here. It is a simple thing, but this point has been addressed by two judges in that case, by Justice Chandrachud and Justice Sikri, both of them writing with enormous sensitivity. They find a reason while upholding the law on passive euthanasia. They say it is essentially economic consideration. That is whether the persons can afford is really a justification for passive euthanasia also, is what they say. Therefore, economic considerations have been given a status to recognize a particular principle of law to be put in place. So therefore, now your hospital takes a decision that 26 weeks is not viable. Yet another hospital thinks it is viable. Then this is typically a situation of withholding a treatment and which, if you want to conform to law, you will have to go to the procedure which I advocated for you, because that is what is, after 2018, the law of the land. You need to say, we won't be able to do this. It is not viable. Therefore, we are not taking treatment. Please allow us to do that. It is a case of passive euthanasia that has to be done. But assure to yourself that there are relatives who are comfortable about that, who are prepared to take a decision. That some other hospital could have done something. You're not fixed against another hospital. This is more an issue of what is standard medical care. I flagged that issue some time back about what Bolam, a case in 1957, England came with a policy which was further dilated and applied in several decisions. Here in India, Samira Kohli was a judgment from the Supreme Court where they recognized Bolam and pitched it against the informed consent, where every information is necessary. It's not merely the standard medical care, which is the yardstick. It should be the level of information which you had shared with the patient and the patient's relatives was important. That was spelled out in USA in Canterbury's case. Justice Ravindran, who wrote the judgment, said, we will not go to that level because India, the medical paternalism still operates. A patient is prepared to believe that the doctor is his God. He does everything which he knows is correct. And therefore, I will go rest with this decision, is how we say. But now, recently, in a judgment by Indu Malhotra, and later with Hemant Gupta and Chandrachud, they have accepted from Bolam, they've gone to the American jurisprudence, which has come through Montgomery, where Montgomery, it was a case relating to a childbirth in England. Of some rare, it was a 4% risk involved in a particular type of medical condition, which the hospital was not prepared to confront. They didn't apply it. And that degree of risk of about 4%, you should have informed. You did not inform, and therefore this merely medical, what the standard medical care is not sufficient. If you are a hospital, if your level of expertise ought to be high, it ought to be in such a state. You need to factor even that 4% or 2% and inform the patient of that medical condition. That law has been now applied in a recent judgment in 2019. I'm not able to name the case, but then this has been accepted now. So therefore, see, if 26 weeks viability is in India, you need to tell them. Some hospitals are prepared to do that. We won't be able to do that. If you want to take the patient elsewhere to another hospital, please do that. This we do as a matter of policy, not viable. If you have medical literature which will support your decision to that extent, I think you should be you are fully armed. And therefore, to make over the patient to yet another hospital where those persons are entitled to take whatever treatment that was possible, that's fine. That I can't do something, I can't be held responsible. Supposing I know what I am capable of doing. Supposing if somebody in a serious state is brought to me and they want treatment from me, I can only say I am a lawyer, I am trained in law, I can't do anything. No, you ought to have treated that person. Can somebody say, or the same way as a person who is just now passing out of medical college and they are bringing a very tough decision, a clinical judgment required to be made, or what probably an eminent doctor could have done is not what a young doctor could have done. So it depends again on the standard of medical care of what that person is capable of doing. So if you say, I wouldn't have done this because our care, our facilities are not sufficient. But hospitals require some basic facilities that's also come through a judgment where they say you don't have even oxygen to be infused, that's not available in your hospital, that is dangerous, is what they said in that case. So therefore, I will take it, doctor, that it is perfectly possible that you take a decision not to intervene in a situation where you find the viability not high.
Dr. Amit from Amit Ghosh from Mayo Clinic, yeah, for your comments.
Yeah, thank you. This has been an eye-opener. I've been here practicing 21 years. I've never heard somebody of the stature of Justice Krishnamurthy teaching us about law. In fact, this is such an important issue that it is taught in every medical schools now. And some of the principle of ethics, which Dr. Krishnamurthy mentioned, every patient has 4 things we talk about. One is the autonomy. The patient has decided to choose what treatment they want, what treatment they want to refuse. This is very important when they are going for clinical trials also. Justice, which is the doctor and the organization deciding with the patient and their family, what is the appropriate test to be used, what resources can be used. That's become very important in COVID. And the third thing is beneficence, that you're going to do what is in the best interest of the patient. And the other is non-maleficence, which is you're not going to do anything which will hurt the patient. I've heard about this passive euthanasia. What we do is a principle of double effect, which is when the patient is terminally ill and in severe pain, you give them a morphine dose or something to take away the pain, and also knowing that the patient will stop breathing, and that's allowed. Now, this has become such an important issue now that we have ethics people here, ethics consult, but it never goes to that level. So very infrequently that we would have or invoke a discussion to the detail that is being discussed here. Part of the reason being that all the things that you talked about, because it's such a gray zone, there is philosophy, theology, cultural aspect, which Dr. Nelam said, because we take care of Middle Eastern patients here who don't want to die in a foreign country, so they have to be kept alive. It has to be put in the form of a discussion, guidelines. Every doctor seeing a patient has to talk about it and not pass the buck to some other doctor. So this is what has happened. Who's going to do? It also comes to the junior most doctor or a doctor in transition, that he needs to talk with the family or she needs to be talking with the family. Very often, very early on, because we have all these parameters now, critical care, thanks to it, they have figured out all these guidelines that we can make out the patient is very poorly prognostic. We call for a family conference and have only one of them being designated. So they can decide if there are 5 or 6 people, we are not going to talk with all of, they can be there, but one person is whom we communicate with. And they decide for the patient if the patient is not able to decide. And we have family conferences every so often days where we don't come to this decision that, oh, this was not talked about. So this is a very difficult situation. It's not a black and white, but since it's a daily occurrence, whatever you do daily, you have to make it your complete the hospital's responsibility and not just the doctor's responsibility to educate, to legislate, to protect the system, to protect the patient, and also weed out bad doctors who don't follow all the 4 principles which I talked about. So this decision, this was a beautiful discussion. There are more questions than answers, but it has to ultimately has to come out by doctors. It cannot go to the level of a magistrate. Very infrequently it should go there. You should be able to handle at your hospital level and have a standard decision across different hospitals. Hospital Fortis cannot have different decisions than Apollo and things like that. So having ethics conferences, whole conferences dedicated, CME conferences dedicated on educating people at the medical school level, residency level, bringing up new laws from time to time. And as the procedures are changing and the more complicated procedures are happening, people are having significant wealth, value of life is going up. People are living more, the relatives are few and far, and patients have to decide for themselves. They have to be educated also by press and by all methods. So I really applaud you for having this discussion today. And thank you to Dr. Justice Krishnamurthy. I'm from Chandigarh, and I know exactly PGI, I trained there, so I know exactly the director you're talking about, the discussion. And this is a very, very timely conversation.
Yeah, back to Dr. Yash. And,
Yeah.
For your
Thank you, Dr. Patta. Thank you, Dr. Kannan sir. Very, very precise points. Those are bullet points actually. And then I like to make 2 points. Dying is inevitable. A good death is not. And Indians somehow seem to die very, very badly. In fact, richer you are, you might have a prolonged and a more disastrous, as against Europe or America, where they have these documents and legal processes in place. So we have to make death also easy. In our zest, we often prolong the process of dying. We are not prolonging life, we are prolonging the process of death. So we have to be very, very careful, especially while we are dealing with patients who are on advanced life supports. And when we talk about end of life care, we always say, Life support may be withdrawn, but care is never withdrawn at the end of life. So we might be de-escalating, withdrawing therapies, withdrawing ventilator, but still our sensitivities and empathies have to be with the families and for the patient. Thank you.
Professor Chandrasekhar, would you like to say something, sir? You can unmute yourself.
There is a particular person, Suresh, who raises a question with such passion, and therefore, before Chandrasekhar joins in, probably to say thank you to everyone, I'll address that. Suresh's question is, as an anesthetist, if I know that there is someone who is coming towards the end, if I'm bringing an analgesic to see that he doesn't suffer pain, if it is given in larger dose, probably it could be lethal. But if I allow a person to die peacefully, will I be held responsible? He is asking. Any pain alleviance of what you administer ought not be an issue. Probably anesthetists, they understand pain better than any other person. So I would, if your act accelerates death, that's a problem. So, but if your act or injection does not accelerate, but only alleviates pain, less pain at the time when he's passing on, then it is acceptable. So therefore, know the difference that you do not accelerate death, you make death less painful. That is fine. You make death less painful, it is acceptable. By killing a person early, I relieved him of pain. That is not acceptable. That is the difference. Yeah. So
Suresh, also Justice Kannan has repeatedly told that there's nothing like a permission from relatives for DNR. Unless there is a proper advance directive which has been signed by the magistrate, even this DNR will have to have a medical board. Then the decision has to be conveyed to the magistrate, and then the magistrate has to sign it, and then only then the DNR becomes legal. Otherwise, it is only a discussion between the family and the doctor. So that won't be technically legal, though it may be the nice thing to do.
So I think as
to conclude,
numbers are dwindling, I think before too long, if it's time to wind up, probably we'll wind up.
Yeah, yes, sir. So Dr. Vasanthi, unless you have some closing comments, we are ready to close. Dr. Vasanthi, you're there?
I think we did I think Justice Kannan gave us most of the answers which you would want to hear from him. But what I'm saying is, what is the application of all this in our day-to-day patients when we have them in government institutions and things like that, when people really don't even know anything about these things. So that becomes whether it's applicable to us. So of course, in corporate hospitals, in private setup and everything else, of course, all that you said applies to us. But in a government institution, in a where you have a lesser economically lesser people working, coming in as patients, do we really have a say on that?
Yeah, if that is a question to me, I'll have to answer by my own experience at PGMR. I had, when Talwar was the director there, I had participated in helping the hospital prepare a withdrawal of life support protocol. I said it should be transparent. You should make it available. If a person is brought there, you should give him a pamphlet and explain how it is done. In all private hospitals may probably retain a person longer than a person wants to be. But in government hospitals, if the patients have a suspicion, I'm probably being jettisoned because somebody else wants a bed, where there is enormous pressure on beds, where a person is not given treatment and then sent away. They always suspect you are, I'm not being given treatment because somebody else wants to be given treatment. Somebody else wants to be given a privilege. So therefore, more than private hospitals, my caution will be only to government hospitals and persons working in government hospitals. That is where the degree of suspicion is very high from the patients and the patient families. The best of treatment was not given. Is what more treatment than what is necessary may be given. A person could be dead in a hospital, a popular hospital, and they'll be doing all kind of injections. They'll be spending another 25,000, 30,000 rupees before they can, which they'll be billing against a person. But in government hospital, the suspicion always is they've not done enough. So therefore, that's where you have stones getting built and you have problems and things. So be careful there. Take the interest interest of the patient to the utmost, to the extent possible. And also take the patient's family along with you. It helps practically. Forget the law. But that's what, if you keep a kind countenance, which we all know the doctors to possess, you will know, you will have no problem. Patients by themselves, they have implicit faith. Their faith in doctors has not waned much. Though there are instances here and there, by and large, the persons who are the highest respected people in India are the doctors. Not without reason, you have such a premium even for college admissions. Doctors are still the most respected doctors.
Thank you.
Somebody reminds you of the template, living will template before the conclusion.
I will do so. I will circulate it to Vidya tomorrow. She will be able to communicate others. I'll give you a format of a living will, which you can probably keep it in the hospital. You can probably create a pamphlet and say, you want to do in your future, you may do this. You can translate it in local languages. Keep that with you. I'll say what is to be done, who will do it. All those things also I'll add. I'll write it in English and give it to her. Not in too long a document. It's a very small document I'll make for Dr. Vidya. She'll be able to circulate it to other members.
Thank you.
Thank you everyone for joining. We've been here for almost 2 hours, and like someone mentioned, maybe there were more questions and answers. But however, those of us in the private setup who've had more questions, now we can kind of understand that whenever we have time, we can constitute a hospital board, take a decision about advanced care, then approach the judicial magistrate, get it signed, and then after that we should be on good legal turf. Am I right, Dr. Kannan sir? Thank you, Dr. Yash, for I know you are probably on webinars almost every day, so thank you so much for sparing your
Pleasure,
time.
madam.
And
Pleasure was mine, madam. Thanks a lot.
thank you, Dr. Vasanthi, for always being supportive of all Marvelous Medicine episodes. And Justice Kannan, if in future we would like to have some session, I'm sure, I hope that you
Actually, Vidya, I want to have a thing of violence against doctors, if that is something which you can take up on one of these days.
I've had occasion to meet and discuss this at Delhi. I'm sure we'll be able to.
What are the legalities involved? Sir, we'll get a date from you.
And then another thing which a lot of people were interested were on about informed consent and other follow-ups of informed consent. And another thing that people wanted to discuss was about death certificate, because now it's when somebody dies, we are most doctors are reluctant to give a death certificate. So about that also people wanted discussion. So I will be disturbing you again, sir, in the coming months for another session on these topics. Thank you so much. Thank you everybody for joining in. Please take care and stay safe, and we'll meet you again next Thursday with yet another episode of Marvelous Medicine.